She's going to speak on American advances and retreats in human rights law. Then I'm going to speak a little bit about American human rights law, and then Ingrid will take over. We'll make introductions as we go. We wanted to leave enough time for questions, so please, you're encouraged to ask questions. Linda.
Can you hear me? Yes, it's fine.
Great.
It's not working.
It's not working.
I think if you're a drop closer, it'll.
Can you hear me now?
Yeah.
Okay. I'm going to be talking about human rights and the possibility for doing human rights class actions. And I'm going to be talking about the history of doing this in the United States. And basically, I'm going to be talking about successes that have occurred, but then also more recently the retreat of the American courts, particularly with dealing with human rights class actions. And my talk actually dovetails very nicely with a number of the things that Professor Coffey talked about yesterday in the context of talking about securities class actions. And the centerpiece of his talk was beginning with the Morrison case as the archetype for how the United States Supreme Court basically started closing the doors to certain types of cases. And he also talked about the F-cubed case. And so there's a pretty substantial literature in the United States about these F-cubed cases. And the human rights cases I'm going to be talking about, they're all F-cubed cases. And just to remind you, that's a case where the plaintiffs are non-American, they're foreigners, the defendants are foreign defendants, and all of the events giving rise to the action occurred outside the United States. So that's why they're called F-cubed cases. All right, so with that introduction, this is human rights in American courts. So the place to begin is how do these human rights cases, how do they even get into the American courts? They need some kind of jurisdictional basis. And so typical subject matter in federal courts is conferred either by diversity or alienage jurisdiction, but we also have federal question jurisdiction. And for the human rights cases, there are two statutes that basically were used or conferred jurisdiction on the federal courts. I'm going to be talking about both of these. The first is the Alien Torts Claims Statute, and then the second, more recently enacted, is something called the Torture Victims Protection Act. Another possible way of getting human rights class actions in the United States would be reliance directly on treaties, but that's very, very rare, and I actually don't know of any cases where that was invoked. And then claims based on customary international law. But again, I don't know of any cases that went forward on that basis. All right, so I just very briefly want to tell you about these statutes because that was basically the jurisdictional basis for these human rights actions in American courts. The Alien Torts Claims Statute is a very, very interesting statute. It's actually very, very short, and it provides that any civil action by an alien for tort only committed in violation of the laws of nations or a treaty of the United States. And for a statute this short, as you'll subsequently learn, it's caused an immense amount of interpretive complications for the Supreme Court, and it's been the center of a lot of recent litigation. The interesting thing about this statute was enacted in 1789. It's one of our oldest statutes, right at the beginning of the country. And what's interesting about it was dormant for 200 years. It just kind of sat out there, and nobody brought anything under this statute until 1980 in a case called Phil Artiga. And this was brought in New York, and it went up to the Second Circuit on appeal. This was a case involving two Paraguayan citizens against a Paraguayan police official. And the basis for the action here was torture in Paraguay. And the question before the court was, well, what was this doing in an American court, and what was the jurisdictional basis? And the plaintiff's lawyer, by the way, must have been very creative to find this old statute after 200 years and said it could be brought under the Alien Torts Claims Statute, and the court agreed. And so basically this laid the basis, it opened the door for hearing human rights class actions in the United States. And the Phil Artiga decision from the Second Circuit said that the Alien Torts Claims Statute could be the basis for filing claims for universally recognized violations of norms of international law. And the types of claims it recognized was genocide, slavery, torture, and murder. And this list was not exclusive. But again, this was a very landmark case for allowing these cases to go forward. The types of violations that are recognizable under the Alien Torts Claims Statute, the list is up there. Again, forced labor, slave trading, murder, rape, piracy, I'm going to be talking a lot about piracy, and genocide. And what was not included in the reach of this statute, which is also very interesting, and this is going to tie into what Ingrid's going to be talking about, but what was not reached by this was a seizure of a citizen's property or causing environmental harms. So that basically was excluded. So we're really talking about a very limited definition of what we mean by human rights violations here. The Alien Tort Claims Statute does not, it didn't define, so this is where the courts had to give content, what constitutes a violation of the laws of nations, but it did identify who is a proper defendant. And you could bring an action against a person who were officials as of the time of the actions that were complained of, or persons acting under the color of basically foreign authority. And the other important point here was that governments themselves could not be sued because we have a sovereign immunity which would operate to bar governments from being sued. All right, the other statute for bringing human rights class actions is the Torture Victims Protection Act. This is, again, much more recent. It was enacted by Congress in 1992. It implements this convention against torture, other cruel and inhumane or degrading treatment. It also established jurisdiction over the types of claims that were actionable under the Alien Torts Claim Act. It applied only to individuals and not to corporations. And again, this was going to be a much litigated issue in recent years. When plaintiffs bring human rights class actions in American courts, they typically bring them under both the Alien Torts Claims Statute and the Torture Victims Protection Act. All right, so now I'm going to be talking to you about two cases. I'm going to be talking about two cases that were successful and then two cases where we've had a tremendous retreat. The most famous of the successful cases is a case called Hilal versus the estate of Ferdinand Marcos. This was, for those, everybody here is pretty much old enough to remember Ferdinand Marcos, the rogue dictator in the Philippines. And by the way, he was still alive when this litigation was brought. He died during the course of the litigation, so that's why the litigation turned into a litigation against his estate. The plaintiffs here were Philippine nationals. It was brought against his estate. The allegations were human rights violations committed against the survivors or their heirs or descendants who are still alive. It was brought in federal court in Hawaii, which was kind of fortunate for all the lawyers who were working on this case because they got to spend a lot of time in Hawaii. And it was brought under the Alien Torts Claims Statute and the Torture Victims Protection Act. So that was the substantive jurisdictional base, and it was brought as a class action, and it was brought as a Rule 23b3 damage class action. So they were seeking compensatory damages. And up there is the class definition of who it included, and there were about 10,000 people who are included in this class. Basically, again, this was a very, very unique case in the annals of class actions, and one of the things that was very unique about it was it actually went to trial. There's been a lot of discussion about how in the United States almost all class actions settle and they never go to trial. This is the rare case that actually went to trial. The court certified it as a B3 damage class action. They implemented a 3-phase trial plan, which was also very, very unique for its time. It was tried in 3 phases. The jury awarded $766 million in compensatory damages and $1.2 billion in punitive damages. And this was appealed. And I'm just going to give you a little bit of the detail about how this was prosecuted, again, because it was quite a landmark case and very revolutionary. It went up on appeal. The state basically challenged everything, but the appellate court, this was the Ninth Circuit, and if you know anything about the political leanings of the circuit courts in the United States, the Ninth Circuit as our president keeps pointing out, is the most liberal circuit in the United States, so it was not surprising that they basically upheld this. They upheld jurisdiction under the Alien Torts Claim Act, and they said even though all the events occurred outside the United States and the Philippines, the American court could still hear it. They upheld the class definition. It was sufficiently definite. They said the claims were typical, so it met all the requirements for class certification. This was what the three-phase trial plan looked like. For those of you who might know something about mass tort litigation in the United States, in the 1980s down through the 1990s, there was a lot of experimentation with multi-phase trial plans that took the different stages of a trial and put them in different orders. And that was what was going on here. So this doesn't look like an ordinary trial. The first phase was a liability trial, just to determine whether or not the defendant would be found guilty and that the verdict was against the estate. The second phase was for punitive damages. Now, if you know anything about the way cases are usually tried, compensatory damages are usually tried in advance of punitive damages, but that's not the way they did this. And before the second phase, the court ordered that notice go out to everybody in the class, so there were about 10,000 notices that were served. There was a 2-day trial on damages, and the jury came back and came up with this $1.2 billion award. The third phase was for compensatory damages. And again, this was done in a very unique way. There was a court-appointed special master, and basically what Phase 3 did was to establish compensatory damages by statistical sampling. And this was pretty much the first time that I know of where statistical sampling was actually used very, very effectively. The special, they had an expert, statistical expert, and they came up with a sample of 137 random cases. And the special master actually, they did depositions of the 137, and then based on that, they had a statistical expert who extrapolated damages from the 137 sample cases. This was again presented to the jury, and the jury basically validated everything based on the expert witness testimony. So again, this was challenged on appeal, but as the slide said, the Ninth Circuit basically approved of everything. And that, when the day is done, this basically told you what the return was to the individual claimants based on categories of torture, execution, or disappearance. All right, so anyway, that's how that was tried. And again, these were the reasons why the appellate court basically upheld it, and it's kind of a standard litany in the class action arena of reasons why courts generally upheld this, which is we can't try 10,000 cases individually. It would be wasteful, it would be inefficient. But again, the landmark thing about this case was trying this based on statistical sampling of damages. All right, and I'm going to run out of time. The second example I have here, and again, this is very, very famous, and I'm sure a lot of people in the room know about this. It was a great deal of litigation relating to the Holocaust era, stolen assets and slave labor litigation. Again, this is the historical timeline for this. The defendants in this case, in the stolen assets, basically were the Swiss banks. This was brought, again, under the Alien Torts Claim Act. And again, this is the different types of claims that were brought. So there were banking claims, there were slave labor claims, and then there were looting assets claims, which is violations of customary international law. This is the chronology of what happened beginning in 1997. By August 1998, there was basically an agreement that was reached. By the way, there's a tremendous article by Bert Newborn, who worked as the plaintiff's lawyer in this case. He wrote a very, very long article detailing the entire history and how this was done. And he used the metaphor that the Holocaust litigation was accomplished as a three-legged stool. And his metaphor was one leg was class actions, one leg was the U.S. Department of Justice that did the diplomatic work underlying this, and the third leg was basically publicity, getting out into the public domain what had gone on here, and those combined to reach this settlement. Basically, this shows how the settlement was structured, the different kinds of classes, the types of claimants who could come in and claim as part of the settlement. Again, there was a bifurcated proceeding here. In phase one, where there was a worldwide notice program, in this notice program, people were given the opportunity to to opt out, and then there would be a fairness hearing. In the second phase, there was an appointment of a special master to develop out an allocation and distribution plan. This was the point of challenge to the settlement of this particular litigation. And the argument here was these class members were asked to opt out before they knew what the plan was and what the allocation was or what they would get. This was very interesting. There was a fairness hearing in two different locations, one in Brooklyn and the other one in Jerusalem. And again, the court listened to the criticisms and the challenges. And ultimately, the court approved this and said the settlement was fair, adequate, and reasonable. And the judge, the appellate court also had to, the district court judge had to determine both substantive fairness and procedural fairness, and he did. So I'm just going to skip through all this. And these are the factors on substantive fairness. In American courts, when you have a settlement, they have to consider both procedural fairness and substantive fairness, and the court went through all of this. All right, and again, I have lots of slides here. This is really drilling down into what the settlement was about. If anybody's interested, I'll send you the slides. But there were large amounts that were basically accomplished in this. All right, now I want to, again, very briefly talk about retreat. So those are two examples where class actions were used successfully to accomplish compensatory damages for victims of human rights violations. We've had a big reversal. The two cases I'm going to be talking about are Kiobel, and my understanding is a lot of people, again, in the room know about Kiobel, very, very famous case. And then last year, our Supreme Court decided a case called Jesner versus the Arab Bank. So Kiobel was an action, I'm losing my voice, brought in the Southern District of New York based on alleged human rights violations that occurred in Niger, and it was brought against Royal Dutch Petroleum. And basically what they were saying was the oil company was in cahoots with the local militia to suppress basically agitation against the presence of the oil companies. The district court basically, Royal Dutch moved to dismiss the case, and the district court basically granted that in part, and there were other parts of this you don't need to know about, but it was a win for the defendant. And the court here basically decided, as part of, this was brought under the Alien Torts Claim Act, that corporations could not be sued under the Alien Torts Claim Statute. This was different than Hillel, where individuals were sued. So this was the new novel question that was raised in Kiobel. And basically there was a dissenting judge on the Second Circuit panel, Judge Laval, basically, who said that he really thought that corporations should not be liable under the Alien Torts Statute, but for pleading reasons, he said it was proper to dismiss the case. So anyway, this teed up the case to go up to the Supreme Court. There were two issues that went to the Supreme Court. The first issue was whether corporations could be held liable for human rights violations under the Alien Torts Claim Statute and the Torture Victims Protection Act. And then the second issue that was litigated was whether or not the Alien Torts Claim Statute had extraterritorial reach. And not to keep everybody in suspense, the Supreme Court in this case did not decide the first issue, okay, which everybody thought that was the major issue that was teed up, and they said nothing about that. But what they did say was that the Alien Torts Claim Statute did not have extraterritorial reach. And we were talking about this last night. I know both lawyers who argued this to the court on both sides. If you're interested in this, the briefs in this case to the Supreme Court are endlessly entertaining because they had to do a statutory construction of the Alien Torts Claim Statute. And they did a lot of legislative historical history. And 40 of the 50 pages in both these briefs were dedicated to piracy. And they said the basic reason for the statute in 1789 was to deal with piracy issues. And when you're reading these briefs, they're going on for page after page about piracy in the late 18th century. And I have, this visions of Johnny Depp and Pirates of the Caribbean and, yo-ho-ho and a bottle of rum. It was the strangest briefs you'd ever want to read. And that was the argument before the Supreme Court. Kathleen Sullivan won this case. She stuck to her script, saying it was not contemplated that there would be extraterritorial reach, and the court agreed. So again, there's just tons of stuff here. And basically they said the statute as enacted was to deal with three things only: violation of safe conduct for foreign diplomats in the United States, infringement of the rights of ambassadors, and piracy. And the decision goes on and on about piracy. It's insane. So there was also a concurring decision by Justice Breyer, who was, and this decision by Breyer, concurring, has had legs, okay, because he thought that the courthouse doors shouldn't be shut to human rights class actions. And down at the bottom it said he would find jurisdiction where the alleged tort occurs on American soil, the defendant's an American national, and the defendant's conduct substantially and adversely affects an important American interest. And in his opinion, Justice Breyer also asked, he said, we're asking the wrong question. We should be asking, who are today's pirates? Which I love that line. All right, so that's Breyer's concurrence. And my last case that I want to talk about, I only have two or three slides. This was decided last year, Jesner versus the Arab Bank. Again, this was brought under the Alien Tort Statute. It was brought on behalf of the persons who were killed by terrorist acts abroad. And the allegation was here was about 6,000 foreign nationals. And was going on here, the Arab Bank is a Jordanian bank, but they had a branch in New York. And the allegation was that money was being laundered through the New York branch, basically, to subsidize the activities of terrorists. And the question that went up to the Supreme Court was the question that was not answered in Kiobel, which is, can corporations be liable under the Alien Tort Claims Statute? And this time, the Supreme Court said yes. Okay, so they answered the question that was left open in Kiobel. All right, and this is also just...
Go on.
Okay.
It's so interesting.
It's so interesting. And then this is like the third shoe that dropped. This was from the Supreme Court in 2014. It's Daimler Chrysler versus Baumann. And what happened here was... This basically was a human rights litigation that was brought about by Argentinians, okay, who had been executed, tortured, or disappeared during the dirty wars down in Argentina. So again, it was an FQ case, but it was brought in California State Court. And what happened here was the case basically got dismissed for lack of personal jurisdiction, not subject matter jurisdiction. And it went up to the Supreme Court, and the Supreme Court said there was no general jurisdiction. It was brought against a subsidiary of Daimler Chrysler, right? Daimler Chrysler has, dealerships in every state in the United States. And the Supreme Court said, no, the presence of a subsidiary in a state that was not an agent for Daimler Chrysler could not confer jurisdiction over the defendant in the case. So what you have here is basically lack of subject matter jurisdiction under the Alien Tort Claims Statute against corporations, and you have lack of personal jurisdiction. So when you take cumulatively what's going on here, that's led to basically this conclusion that the American courthouse doors basically have been closed to these types of cases. And so I would leave you with just one or two thoughts. Should these cases even be in American courts when you're talking about a classic FQ case? And the message that's clearly coming strongly from our Supreme Court is no, we don't want to hear these kinds of cases. But that leads to the next question. If the American courts don't want to hear these, where do these cases go, right? And where can they be heard? And I will just leave that out there, and I'm sorry for taking up more time.
On the contrary, that was tremendous. Thank you so very much, Linda. On the contrary, I thought that was stupendous and left open myriad questions on lots of different levels. Hopefully we'll have time to come back to it. I will be very brief, and then I'll pass the microphone to Ingrid, and then we'll take some questions. I will just say personally that I was the law clerk to Judge Corman, and it has been incredibly striking to me from Judge Dow's comments yesterday, from what Professor Zakharov said this morning about Volkswagen, so much of this, we think as lawyers that we have a big role in these cases, but it is fundamentally whether you have an activist and engaged judge. Judge Corman had no need to come to Jerusalem to have a fairness hearing, no need to reach out in the myriad ways that he did. This is on the public record. It's the same with Judge Breyer. If you get the chance, if you're interested in Volkswagen, you can read every month he had status conference hearings. And we, Leif Cabraser, were lead counsel, and Elizabeth Cabraser is a giant, a titan, and no one worked harder for that settlement, but Judge Breyer really drove that home, and so many of these cases turn on whether the judge is, whether she is or he is completely engaged in this. As a side issue, but something that's just really fascinating. I want to talk about a contemporary case that does not have one F, let alone F cubed. It is a domestic case in the United States that our firm is involved in, and it is the USC Student Health Center litigation, which results from the horrific misconduct of USC, and in particular, its gynecologist, obstetrician, George Tyndall. I just want to talk about 3 parts of the settlement because it is a domestic human rights case that has, in my view, some really interesting intersections between human rights, class action. You'll see an issue class coming through. You'll see that plaintiffs' lawyers are sort of marrying together all of these factors, but also, admittedly, commercial interests. Linda didn't talk about it, it was on your slide, that the lawyers in the human rights litigation, the Holocaust litigation, many of them donated their fees to good causes, including a professorship at Columbia. And while that was tremendous, there's also a drive to make money in these cases. And this case that I'm just going to talk about has a piece of that, sort of doing well by doing good. I want to just tell you a second about the case. The short version of the facts is that for many years, USC, University of Southern California, Los Angeles, was aware that this doctor was essentially raping, violating, and mistreating students. And there were 400 incidents of sexual misconduct amongst 17,000 women, and those are only the 400 that have been reported. This case was filed last year, and a settlement was reached in February of this year. So it moved very, very quickly. This is in federal court in the Central District of California, Los Angeles. There's also state court proceedings, so there are all sorts of really interesting parallel proceedings, which we don't have time to get into. I'm just going to tell you a drop about the settlement. The preliminary approval hearing is on Monday, so it's live. There is a financial component and a corporate governance component. The financial component has 3 tiers for women who want to participate. There is one level of payment simply by being a member of a class. There is a next level of payment for submitting a form, and then there is another level of payment up to $250,000, which I think is in excess of the money that in Filartico, albeit many, many years later. But it's interesting also to compare the damages. Again, we don't have time for that now, but and so it has a whole financial piece. Then there's a corporate governance piece, which is, to me, just fascinating. Don't have time to get into all the pieces, but there's an oversight component, an investigative component, a component of addressing claims, and then what I think is truly fascinating is there's a committee called the Equitable Relief Committee that has been created at USC to ensure that not only do claims and investigations happen sort of according to the letter of the law and the letter of the settlement, but also the spirit, which is, I think, for litigation, a specifically and unusually nuanced and tailored to this particular trauma, really special. I want to, just in 2 minutes, read you a section of a letter from a class member, which I think also, one thing that we have not really done today and yesterday is we've talked sort of from different angles, but not from the perspective of the class member, the victim, the consumer. And this letter, I think, is really insightful in this way. And then I want to just talk about issue classes for a second. So I'm jumping all over, but in the interest of time. And the letter was sent to the Daily Trojan, so, quite a name for the USC newspaper, and it's just an extract of it. It's entitled "Why I Believe the $215 Million Class Action Settlement Reached with USC is the Right One." And the author, who is an alumna of USC, says, "One part of the agreement that is so important to me is that it provides choice. As sexual assault victims, we were never given a choice. Under this settlement, every woman, regardless whether they choose to share their story, again, the different forms of compensation and participation, or not, is acknowledged as a survivor. That should never have been put in harm's way." Point one. Point two, and this is really, to me, like the electric part of being a class action lawyer, is the sort of unity that you have as a class member that's often seen as a sort of, maybe not as a weakness, but it's sort of seen as part of a herd. This is really a virtue of this settlement. The settlement also gives survivors a chance to unite for the betterment of an institution we all care about. People talk about class actions as trying to sort of challenge the institution that they litigate against. This is not the issue here. One of the most difficult parts of my assault was what I thought I was Tyndall's, this is the monster at issue here, his only victim. Now I know I'm not alone. I have thousands of women standing beside me saying that we will no longer tolerate this terrible behavior. I draw my strength from the courage of the other women who have stood up with me against this sexual predator. Finally, one of the strengths out of this strength and solidarity, we have developed what may be the most important part of the settlement, a series of changes in policies and procedures at USC. After years of carrying this weight alone, this settlement represents closure for me. So again, we're talking about the Wickham statute yesterday. We're talking about the global release that the companies want. This is a global release that the victims want themselves. This provides, in my immodest opinion, real strength on both sides of that. John will be talking perhaps about privacy and the virtues of privacy, if not entirely, because again, we won't have enough time. But this is another piece of the settlement. I was able to choose whether to put my real name on the lawsuit or to file as a Jane Doe. Absent class members, a virtue of being an absent class member. Okay, I'm going to shift very quickly with the time I don't really have to just read you a section from the preliminary approval brief, which talks about the ability to have an issue class. Again, Professor Zakharov was talking about this morning, and how the aquifer case that he was talking about. So here we have some of the common questions to the class include whether, and I hate reading some of this stuff, so I'm going to abbreviate it, but whether Tyndall engaged in sexual harassment, evasion of privacy, assault, battery. You talked about rape as one of the causes of action under the Alien Tort Claims Act, so it's the same here. And in a case like this, where the exact factual circumstances of each class member's injury may vary, commonality exists where a course of conduct subjects all class members to a similar risk or threat of harm, and gives a number of cases supporting that. And just to mention a few, there's a 10th Circuit case, so it's not the liberal 9th Circuit. The 10th Circuit case, DG versus Devon. Though each class member may not have actually suffered abuse, again, these are people who may not even have, suffered the actual violation, conceivably, neglect or the risk of such harm, defendant's conduct allegedly poses a risk of impermissible harm to all proposed class members. I could go on, I don't really want to right now because we have a wonderful other speaker who I'm now going to introduce, but I recommend that you follow this case. One of a number of superb outcomes of VW is that there are lots of, you can find much more about cases on the court's docket than you could ever before. It's just a ancillary virtue of Judge Breyer's genius in VW. So this is, again, and this is in re USC Student Health Center litigation in the Central District of California. You can follow this case in real time. Anyway, that is all I wanted to say about that. Now I have great pleasure introducing our last speaker, Ingrid Gabay, who previously was masking as Hans Micklitz. Now she is her true self. Ingrid has had a remarkable career, is currently a senior partner at Hausfeld in London, and is going to talk about some important human rights cases that she's working on. Ingrid.
Thanks, Nick. Thanks, everyone, for coming along to this session. I'd just like to quickly say something about Linda's wonderful presentation and the concept of piracy, and perhaps, and I'm sure you'll be familiar with this, but what we're seeing, of course, is this polarization in the courts, where we've got the conservatives, or the eagles and doves, those who are the originalists, going back to what did it originally say, what was the intention of the original people 300 years ago, 400 years ago, what did they think? Anybody's guess, really. And those who say, well, we should be dynamic and interpreting it in the modern light and keeping these things alive, and because they're useful instruments, and we should continue with that. So we see the originalists versus the dynamists continually in this engagement of statutory interpretation, more and more, not just in the US, but in the UK and in many places where there are sort of the rise again of neoclassical theory and so on. So, you know, if we looked at piracy, we could easily say, well, we could be talking about information piracy, hacking, you know, cyber, all of that. Cybercrime is piracy, but no, we're still stuck with shipping and mercantile shipping and so on, and the romantic notions of 700 years. So I think it's pause for thought that we are, as other speakers have referenced today and yesterday, in a time when the courts are getting into a conservative space again. Our political institutions are in a very conservative and chaotic time as well. So where do we go? And Linda asked the question, what court? But generally, where do we go? Do we use the political institutions and campaign? Or do we go to courts? Or do we go to the people? And more we're seeing activism amongst the people generated through this time of conservatism. So I think we're seeing that in the US, and we'll cite some cases now, and we're seeing that in the European context. And so that leads me into a discussion about where we are on the human rights side and what I'm doing in my work and other people like me. So I, of course, are known here as, you know, my consumer world days, developing consumer acquis with other people. Ulrich from Austria is here today, and many others. In a time when there was no actions, nothing was happening, and we sat around and, you know, nothing happened. And so we watched the building of that over many years, to the consumer acquis, to, you know, the development of collective actions in different states. Now we're seeing, you know, some movement around that. And in the same way, obviously the environmental movement has been an inspiration, and I said, referenced yesterday, the comparative heads that we now have. For those of us who have worked in building systems, in building frameworks of liability, in building the possibility of bringing actions, you are able to borrow and adapt where it is desirable and appropriate across the spectrum a little. And I think, you know, whether you're academic or whether you're a practitioner, and as a practitioner one needs to be creative, you need to look at these frameworks. So in the environmental world, we've had leaps and bounds. From the 80s, of course, third generational human rights, as it's known. So we had the traditional human rights of traditional genocide, civil and political. Unfortunately, they keep coming back and keep coming back. They haven't gone away. The secondary with economic and social rights and housing and health. And now the third generational rights, which are basically collective looking, collective groupings, environmental, and that's what I mean when I say third generational human rights. My space moves between third generational and first generational, generally across the spectrum. So I work with NGOs, I work with communities, We are known for our cases. Currently, there's a very small little cadre of firms in the United Kingdom who are able to bring transnational litigation. We are one of those. We gave evidence with 2 other firms to the all-party joint committee, parliamentary inquiry and business on human rights, on all the barriers to access for foreign plaintiffs trying to get access to the United Kingdom courts. We are currently investigating and litigating claims around mining companies and communities. I won't say too much about the silicosis case because I just learnt that we have a lawyer from the mining company, but now I can say that's resolved successfully in South Africa through the London and DC offices working very closely together. As you know, South African law mirrors English law, so that's quite helpful. And South Africa, of course, had their first class action through silicosis and the bread competition cases. So we've been able to drive a little plough through that. Now, at the moment, we're sitting around with our communities who we act work for from Zambia in a big mining case. We agreed with another firm that they would test the jurisdictional issues, because the first barrier we have in the United Kingdom for bringing multinational company type of litigation is jurisdiction, of course, as you would expect. So the issues there are, this subsidiary and parent. We can only bring the case if the parent is headquartered in the United Kingdom. And we have to show that there is control, an element of control over this subsidiary in order to be successful. At the moment, that particular case of Vedanta has been successful at the 2 lower courts and now has just been heard in the Supreme Court, and we're waiting for the judgment on that. Once we have the judgment from that, we can go ahead with the communities who are standing by. So that will be an interesting one to watch. In the meantime, because we have these barriers, those cadre of lawyers who are busy bringing those cases also have to be busy giving evidence to committees, doing the policy work and the reform work, because they're the main practitioners in the space in the United Kingdom. The cases are not generally being brought other than the Netherlands, in other jurisdictions for various reasons, as I think you're all aware of the hurdles in other jurisdictions, so I won't go into that. And so we are working on human rights defense, human rights due diligence as a mandatory instrument in corporate behavior. So that goes into the prevention side. So we're busy with the prevention side and we're busy with the remedies side. How do we also keep up the remedies side of the 3 pillars of John Ruggie's pillars, which you're all familiar with? I won't go there because of the time. But we're busy with both. So how do we prevent these terrible corporate abuses from occurring amongst some rogue companies? And then how do we give adequate remedy to those claimants at the end of the day when they go to court? So obviously in the meantime, when we're giving evidence, we talked about the fact that group actions were unavailable in many jurisdictions. This has been taken up by the Office of Human Rights, the UN Office of Human Rights, who sought an opinion, which we all fed into. It's now being taken forward by the Fundamental Rights Agency at the European level, and we expect them to publish very soon. Jonas Grimheden tells me that they're going to come up with their publication on that in the end of summer. So it's been moved from March to the end of summer, so we will hear that. Clearly, we have a confluence here with consumer movement, because we are asking for the same things, though for different reasons and different outcomes. We all need greater access for our foreign plaintiffs, for our consumers. Now we're dealt with anti-competitive conduct in the UK for the opt-out. So slowly, sector by sector, which is the UK approach, we hope that we will see more of a carve-out. And that carve-out will come through the cost rules. We're asking for one-way cost shifting for claims of this type. And so we have quite a few things on the table now. Obviously, the government is extremely busy and has a few things keyed up and queued up And it's possible, as one Indian friend of mine said, the British take a long time to leave. So I expect we'll probably have a very similar situation here. And then all the queued up policies will start to get more attention again. So I just wanted to briefly outline that we do the transnational litigation, and that's an extremely important part of the human rights practice. We also do national litigation, so we're just very happy to announce that the Chancellor and the Spring Statement has announced that the government will fund free sanitary products in all schools and colleges in England, which is the case we brought is an equality case. It was brought by a young campaigner of 17 years old who saw that, this terrible 1 in 10 girls, we say children because there are some transitioning, are not attending school because they could not afford sanitary products. These statistics come from the UK Plan International and even UK Gov. So it was extraordinary and appalling that we had the statistics and yet we had no remedy. We collected through Crowd Justice, which is a funding platform very suitable for this kind of campaign because a lot of people were very emotional about it. A lot of people felt strongly about it. So we set up a Crowd Justice platform. We put together the equality filing for a barrier to access for girls. Clearly, there was a problem there, and it was a case that was very overdue. And just before we filed, and after our letters were sent and there was correspondence, the Chancellor announced to our great delight that even though they had these big problems going on in Westminster, they would somehow find the funds to fund all schools and colleges in the United Kingdom the way they have in Scotland last year for free sanitary products. In the meantime, we've been written to by US states, New Zealand, India, Australia, saying we have the same problem here. When are you coming? It's overdue. How come condoms are free and not menstrual products? What is going on? So we've written back to them. We've advised US lawyers. Obviously, it was a big issue in the US with menstrual equity. We've spoken to those lawyers. They're assisting other lawyers, etc. We're meeting campaign people. So campaigns of this kind, which come from the young people, and I'm going to go there next, are very motivating, very suited to crowdfunding platforms, and extremely successful because you have a powerhouse of energy of people they're doing the media, they're doing the article writing, they're speaking with journalists, and all you have to do is get on with the legal job, basically. So that really was great. So that's turning my attention now to climate change. How much time do I have, Nick? In 3 minutes.
You had 3 minutes about 5 minutes ago.
Oh, okay. I'm going to abuse the panel, and I'm going to go on and talk to you a little bit about the climate work because we set up the London Forums for Climate Change Litigators in 2012 when there was nothing happening. And all the people who were from the environmental movement, environmental lawyers, people who were interested in setting up frameworks for liability around climate change, lawyers, technicians, policy people, government people, campaigners, all met in our rooms along with a spider phone so that we had people coming in speaking from South Africa, people talking from Agenda, obviously in the Netherlands. Lots of people were speaking together about how to get this nascent idea of climate change kind of actions going. And this is before the Paris Agreement. So then we have the Paris Agreement. A lot of the landscape changed instantly overnight. Everybody felt empowered to bring actions. And along with that, in the UK, we have the Clean Air Act. And so we started air pollution litigation as well. We're working with medics on that. We're waiting for the outcome of an inquest in another case to see whether there was an atypical asthma there, which may indicate that, we have a clear run. So air pollution litigation. In the meantime, I've been working with young people bringing cases, Portugal, India, Pakistan, obviously the US Child Trust case, who very brilliantly, in their latest move, have asked for amicus from foreign youth. So it's a way in and around the Alien Torts Act to get these amicus briefs from foreign youth into their case. I thought it was a brilliant move. And where does this all leave class actions? Well, you might ask, we are now at that stage where we're setting up that liability. So all of the letters have gone out. I'm not talking just about us, but lots of NGOs, obviously Client Earth and many other people we work with, sent out letters, they've sent out notices to regulators of pensions, to company fossil fuels, to everybody else is now on notice, very much on notice. This is the way you lead to strategic litigation. You pick your cases, you put everybody on notice, you tell them that you have not disclosed the climate risks, you bring your litigation, and you get your damages, and that is where we're heading next. So on the human rights world,
but a long one.
We're not American, we're very European in the way we approach things here. Yes.
Okay, so we have time for 15 questions. No, we have no time. Thank you both. Thank you, Ingrid.
Thank you.
To be continued.
We move to the next panel. In the meantime, if anybody wants to
Thank you.
Very nice. I wish you could speak longer.
Well, next time maybe.